The Law Society of Kenya is now urging its members to boycott the courtrooms of 5 judges declared unfit for office by the Judges and Magistrates Vetting Board, but were reinstated by the court. LSK warned that it will petition Parliament to amend the Constitution to compel all judges to resign and apply for their positions afresh. These, as chairman of the Parliamentary Committee on Legal Affairs, raised concern over the credibility of the judiciary as the country gears up for the next elections.
A legal tussle is brewing between the judiciary and the Law Society of Kenya. The latest incident occasioned by a move by reinstated Judge Justice Joseph Nyamu, who has sought a court order to gag LSK officials from talking about his reinstatement. Nyamu feels the LSK is too vocal on his controversial reinstatement to the bench by the High Court.
This latest move by one of the judges who has been declared unsuitable to serve is a further attempt to make sure that anybody, especially the Law Society of Kenya, which speaks against the attempt to scuttle the exercise, does not see the light of the day.
After the post-election violence, one of the main aims was to have judicial reforms. This was to ensure that we clean out the rot from our judicial system. But the latest decision by the High Court has been deemed curious, and most people are now bringing the credibility of the judiciary to question.
It has interpreted the law to actually disregard that clause.
In an act of protest, the Law Society of Kenya is now determined to make the judges know that they're not welcome back in the Kenyan courtrooms.
We want all the lawyers to take a position that they would not regard those judicial officers as officers of the court, and that they should not appear in their courts as judges or as magistrates.
The LSK, the Attorney General and the Judicial Service Commission intend to appeal the ruling by the High Court. However, given that the case could be heard by judges who are yet to face the vetting process, officials of the Law Society are not taking any chances and will opt for a permanent solution if the Court of Appeal does not rule in their favor.
Or if it means petitioning Parliament, if it doesn't require a referendum, then we need to start that action now, so that come April next year, we can have all the judges, all the magistrates, whether you have been vetted or not, resign.
I don't even think there is any question about amendment to the Schedule 5, Section 23, Subsection 2.
The chairman of the Parliamentary Select Committee on Justice and Legal Affairs, Njoroge Baya, says there's no need to amend Article 23, Subsection 2 of the 6th Schedule that bars the judiciary from contravening decisions made by the Judges and Magistrates Vetting Board. He adds that there is a need for the Court of Appeal to rule in favor of the Kenyan people.
It's a very unfortunate decision by the High Court, because the High Court, in our view, has failed to capture the moment which was really to help the process of vetting of judges and magistrates to continue conclusion.
Baya says the Court of Appeal must make a ruling that is constitutional, more so now that the country is going into an election, and the judiciary must remain to be seen as credible and impartial. After filing the notice of appeal at the Court of Appeal last week, the State Law Office is now awaiting a date for the hearing of the appeal. There is a sense of urgency on this matter, given that the term of the Judges and Magistrates Vetting Board, chaired by Sharad Rao, ends in April 2013. Catherine Omwando, KTN.